Well, hello again, everyone. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. What else? So today we're continuing on our Regional Center Compliance series, and we're going a little bit deeper into the Form I-956F. So this is the third webinar we're doing on the 956F. The first one we presented was on the elements of the 956F filing under the EB-5 Reform and Integrity Act of 2022, or the RIA or RIA. The second one focused on a very important component, a very important element of the 956F, the comprehensive EB-5 business plan, with my good friend and EB-5 luminary, Suzanne Lizicki. Today, we're going to be a little bit practical. We're going to have a practical focus and cover some of the do's and don'ts of the 956F filing, based on recent RFEs overcome that our office has handled in the recent months. So without too much further ado, let's do a little share screen, shall we? And we have to start with a disclaimer. This presentation is informational only. No part of this presentation is legal advice. There's no attorney-client relationship that's created without a signed engagement agreement between our firm and a client. And the content of this presentation may be promotional and should be considered attorney advertising. Any timeframes and estimates that we discussed will vary widely, and our contents are copyrighted. All right, got to do this. Got to tell you a little bit more again about our practice, and you are welcome to check out our website as well. Very proud for the opportunity to have served as a leader in the EB-5 space. I've served 6 terms as chair, co-chair, and vice chair of American Immigration Lawyers National EB-5 Committee, where we've done some amazing work in the policy and legislative arenas. Working directly, I would say, with USCIS in formulating policy by way of our scholarly contributions and commentary on proposed and published policy. I've also served as legislative counsel to Invest in USA, or IIUSA, and in that capacity, I had the opportunity to work closely with legislative staff on the content and the passage of the EB-5 Reform and Integrity Act of 2022, which is the universe in which we are all operating today. On the client representation side, I couldn't be more blessed to have amazing clients on both the project side and the investor side, representing over $2.5 billion in EB-5 capital raised. That's not including other capital that's been stacked with EB-5. And having represented both project and investor clients through the entire cycle of immigration, through 829 approvals, and indeed beyond, in advising clients on both sides of the aisle, if you will, on redeployment and sustainment of the investment. Thousands of investors have trusted me and my team with their incredible EB-5 immigration journeys. And I'm so proud to have taken them all the way to the end through 829 approvals. All right, well, I can't do this on my own. I've got an incredible team that I'm also proud of, and our clients love working with. We have 8 dedicated professional team members. All we do is investment immigration, and so this is all they do. And 7 have advanced degrees, including master's degrees and PhDs. And excellence is our standard. We spend a lot of time refining, tweaking, discussing our process and service so that we hold to that excellence, which is our standard. Of course, we are assisted by technology. Our firm might be one of the unique firms in our space in that technology, embracing technology, is a part of the DNA of our firm. And so we rely on our proprietary bespoke C-Flow client management system that we have developed specifically tailored for our investment immigration service. All right, enough about us. All right, so some background. This is important and it's worth going over whenever we talk about the RIA. The RIA is a part of the fabric of our immigration nationality laws, codified in the Immigration Nationality Act, or the INA. The regulating agency is the U.S. Citizenship and Immigration Services, or USCIS, which is housed under the Cabinet U.S. Department of Homeland Security. The Regional Center program is a pilot program still. It is not permanent, and it was created in the early 1990s. And our current iteration of the EB-5 Regional Center program, under which we are all operating, is the EB-5 Reform and Integrity Act of 2022, which will again sunset in 2027. So this is a topic that I'll be talking about from now until we have permanent EB-5 Regional Center program legislation. We will be talking about that advocacy from now until 2027 in great detail. Okay. The 956F under the RIA. So just a bit of context again, exemplars or project pre-approvals were not required pre-RIA. They are mandatory and required under the RIA. Approvals are not required, but the 956F, which presents project eligibility under immigration laws, must be filed before investors can begin filing their associated I-526Es for that particular project. Now, the RIA sets out elements that are required to be a part of the 956F. There are 6 statutory elements, and the comprehensive business plan really is the most important part. It's the summary. It is the undertaking, the project, the EB-5 project that is the subject of this capital investment. It's got, of course, other important elements, including an economic impact analysis, full disclosures, investment documents, policies and procedures as to how the project and the associated regional center will remain in compliance with all applicable laws. And as I mentioned, proof of the filing of the 956F is required for all of the investors associated with that 956F or regional center project. A recap of the 956 elements, and they are also in the Form I-956F itself. So the regional center, who is the associated regional center, that is that comprises the first 2 parts of the Form 956F. We've got to identify the new commercial enterprise, the NCE or issuer associated with the 956F. We also have to identify the job creating entity, the entity that is the ultimate user of the EB-5 capital for job creation purposes. We've got to talk about the project. That's in part 5. We've got to talk about the job creation, whether it's located in a TEA, etc. We're going to be talking about the investment and offering to make sure that the required disclosures are all in place. And we're going to have a section that confirms that policies and procedures as required under the RIA are also associated with the filing and have been made. There are required certifications of both the regional center filer and the issuer on the Form I-956F. Sometimes there are different parties where there's a third-party affiliated regional center involved. So we've got to be mindful of that. Part 9 has all persons associated with the project, the regional center, the new commercial enterprise, and if the JCE is affiliated, the affiliated JCE as well. And each of these persons will have to file a separate Form I-956H. Part 10, fund administration, very important. This is a new construct of the RIA. Projects will have to ensure that they follow the fund administration requirements of subparagraph Q of the RIA, or make sure that they fall under one of the exceptions or waivers. Part 11 is where the authorized individual makes required certifications and also signs the form. Okay, so the business plan we talked about in good depth and during a fun conversation and informative, I hope, with Suzanne Lizicki. So please check that out. We'll have a link to that webcast with Suzanne in the links below. And the business plan's purpose is really to talk about how the new commercial enterprise, the NCE, is going to create the required jobs. And to do that, EB-5 law requires a great level of specificity and detail along the elements described in the precedent decision matter of how. I'm not going to go into that in this presentation because we covered that so well last time. The business plan exhibits will have lots of supporting evidence that support the key aspects, the key points that the business plan discusses to talk about how feasible, indeed how likely this project will create the required jobs, how poised it is to create the required jobs, to enable USCIS to conclude that yes, there is sufficient feasibility of job creation as required under the law and regulations to approve this Form I-956F. And the elements are listed in this PowerPoint, and these are the elements that we collect in the course of I-956F preparation for our clients. Okay, so based on all of that, let's talk about some of the do's, and we're only going to lightly touch on these to give you a sense of the elements of a winning 956F. And then on the flip side, we're going to talk about some pointers in terms of what to avoid, the don'ts of the 956F as well. And then we'll open up for some questions that we already have in queue. All right, so in terms of the do's, do ensure that the business plan is comprehensive and comprehensive along the dimensions espoused in the matter of how precedent decision. So one of the things that we have seen in RFEs that USCIS is really looking for and is focused on is a clear project timeline. When is it going to start? Or if it has it already started? Where are the significant milestones of project development? When is the project anticipated to be completed? When is it expected to be operational? In short, when is the project going to achieve completed job creation? Now, there is a tension here between the presentation of that level of clarity and concreteness and the fact that really a business, a project, is a living thing. I mean, I really envision it almost as an organism. It is not static. It has a life. It is reacting to all sorts of stimuli that contribute to affect its development and ultimately its success. And so how do we square that? Where this tension is most often presented is in the start of a project. So one of the more common RFE points that we'll see is there is a discrepancy here in your project timeline in terms of your project start. You've said X, it's going to start in the first quarter of 2023 or 2024. And here we are in the third quarter when the RFE comes. And it appears, based on our review of other records publicly available, and maybe even in your internal filing, that say that the project hasn't broken ground yet. Where resolve this discrepancy for us. Sometimes it's real easy. Sometimes the RFE is pointing to, you know, a Google map that's several years old when it's, you know, we had undeveloped land, for example. Other times there is a delay and we've got to explain what that delay is about. So setting out the timelines, being prepared to respond and answer questions about any discrepancies is important. Now, as I kind of alluded to, the consistency of the facts presented, and especially about the timeline, is important. So at minimum, we'll want to make sure that all of the documents are singing from the same hymnal. You know, maybe there will be a delay down the road, but at least you certainly want all of the submitted projects to present consistency. So you don't want your private placement memorandum to talk about, you know, a Q1 2023 start when your economic impact analysis or your business plan says, you know, Q1 2024 start. Got to be consistent. Consistency also is the equivalent, is a proxy for credibility, which is why it is so important. Do have the commitments in place for the full capital stack for project development. And this is another common element of a request for evidence or an RFE. So typically, an EB-5 project presented on a 956F is going to have different capital sources. It's going to have often now a senior commercial lender. It's going to have at least it's going to have an equity component from the project developer, and it'll have EB-5 participation coming in somewhere, maybe as mezzanine debt, maybe as preferred equity, and that will all comprise the capital stack for the project. And when those funding sources are not all presented in the 956F, you can count on an RFE coming down and asking about it. And moreover, asking for commitment. It isn't sufficient to just state in your business plan, well, we're going to get 80 million senior debt, we're going to contribute 20 million in equity, and we're going to raise 50 million in EB-5. We've got to have those commitments in place. Do present, this is the overall point, the overarching point, a shovel-ready state of your project. So a business plan where we haven't closed on the land, for example, I would be concerned. So beyond that, we want to show, yes, the land is acquired. We have permits in place. We have the key development contracts in place. We've got the A&E, we've got the construction. Ideally. Some more do's. Do ensure your economic impact analysis is consistent with the business plan. Now, consistent overall, this bit of consistency, this specific area of consistency is critical. So your business plan is in essence your manual for the inputs that are driving the economic impact analysis. It's talking about the CapEx for the project, and it's presenting it in narrative form and all of that. those numbers are fed into the economic impact analysis as inputs. And so there has to be consistency there. If the numbers are off, and they could be in good faith, you know, we could have, because again, these are living endeavors. So the business plan draft might be capturing one point in time, a snapshot in time, and the economic impact analysis could be capturing another point in time. You want them to be consistent. To ensure the economic impact analysis uses the new RIA job creation formulas. Under the pre-RIA regime, we had certainly policy gloss over when we can count indirect impacts and rules for construction, what kinds of inputs and so forth. The RIA has specific formulas about, for example, importantly, the maximum level of indirect jobs we can present for job creation purposes. There's a maximum of 90% of the required jobs that can be satisfied with indirect job creation. And you can look to our previous webinar about 956Fs and projects where I go into the RIA formulas in more depth. Do be prepared to file Form I-956Hs for all persons involved in the regional center, the new commercial enterprise, and if the JCE is an affiliated JCE, the affiliated JCE, because under the RIA, all persons involved with these entities are required to file a separate 956H. And a person is involved with these entities if the person is in a position of substantive authority. And if there are questions about that, and there indeed are, we're happy to consult on that. Do feel great about the undertaking, about this exciting new project. And I find that that's really the best part of all of this is this is good stuff. It is unquestionably good stuff when it is good, when you've got a great project that is creating American jobs, that is bringing capital, that is going to help families all over the world gain a new start in the United States, achieve the American dream. That is the vision of Congress. And so to have that excitement is excellent because that will infuse the enterprise and your documents. And everybody who's associated with it. So let's go into some of the don'ts. And so I've tried to weigh it so that we have more do's and fewer don'ts. Don't skimp on the business plan and economic impact analysis. It is way too important for these to be drafted beautifully, presented well, and of course, to meet USCIS RIA requirements. That is our job. It is much better if we are working with other experienced professionals who know how to do this. Hire experienced experts. They are worth it. Don't file unexecuted documents. Again, you know, this is really, you know, kind of like crossing the T's and dotting the I's. There are iterative drafts. Let's go with a final, fully executed, buttoned down versions of all of these important documents. Same idea. Don't send draft copies as finals. Let's get the fully negotiated, fully executed documents in beautiful shape, form, in. Do not rely on prior good luck on prior approved projects, whether it's actually a previously approved 924 exemplar application for the same project, or whether it's a brand new project. you've got to treat the project as standing on its own. We are in this new regime of increased oversight that we all asked for and we got. So this is, we may have had a stroke of good luck with an early 924 exemplar that got approved. Assume that these standards imposed by the RIA, they're not opaque. They are requirements that we need to take very seriously and be methodical about. Don't assume you can count all the job creation from earlier phases or activity of a project unless you have a sound bridge financing theory and supporting documentation. This is important and way outside the scope of this conversation, but bridge financing, that relation between earlier job creating activity and later arriving investors and their infusion of capital into that project's timeline is very tricky for lots of reasons. And so if your project is going to have that component, you've got to make sure that you're well advised on that. Don't bury weak spots. As I like to say, every project has some hair. There's no project that doesn't. And so there's no reason to pretend that it's perfect. If there are weak spots, and there just will be, we don't need to bury them with, obfuscating documentation and language around it. Let's address them and have the confidence that the project as a whole is manifestly feasible and that any reasonable examiner is going to find the same. And that's what we do, is we deal with those challenging aspects of any and every project, and we present them in their context, right? So don't be afraid. Don't confuse, this is a similar point, don't confuse voluminous with comprehensive. Yes, we have to be comprehensive, we have to be specific, we also have to realize the art of leaving us a little flex room too, but that is not to be confused with volumes and volumes and volumes of documentation. When I encounter those 956Fs in the course of my review for investor representation, I just go, wow, well, I'm not sure this is really serving the purpose here. Streamline, but comprehensive. Don't forget about the end game. Just keeping the culture of that mindset in as you do this, as you prepare the 956F. Ultimately, it's about getting your investors through to conditional permanent residency, out of conditional permanent residency, meaning 829 approval. And how do we do that? Completed job creation. So adopting that mindset is going to inform the drafting, the preparation, the elements of the 956F, keeping in mind that some years into the future, we're going to be proving up everything we say we're going to do at this stage. Okay, so we have a lot of resources and they're constantly in development. We're going to give you even more regional center and EB-5 project resources. And you can check out our website under EB-5 services, where we talk about these requirements and our support. And also our YouTube playlist that's got our regional center and project focused webcasts all in one handy spot. So I'm gonna just take a couple of questions at this point. I've run over already. Okay, so questions via registration form. May you please send the recording? Absolutely. Everybody who registered we'll get a link to the final presentation. Is the auditing process for regional centers affecting the approval of 956Fs in any way? Great question. We are not aware that it is affecting the 956F. And indeed, there is language in the RIA that we were very careful to draft in there that if there are amendments or other activities associated with the regional center, that will not delay adjudication of the regional center related applications filed before then. So I would say listen and look out for it. And if there are instances of this, to please contact us, because at minimum, I would want to know. Can you discuss what constitutes an affiliated JCE versus non-affiliated JCE? Great question. So the concept of affiliation has to do with common control and ownership. Common control or ownership, I should say. So if you have two entities that have any overlap in ownership or control, then they may be affiliated. And you might have to check that they are affiliated on the 956F and provide 956Hs for the persons involved with that affiliated JCE. If they're completely at arm's length, there's no overlap in ownership or control, then they're not affiliated, and you can proceed that way. Fantastic. Well, thanks everybody for joining me live. Check out our regional center playlist if you have other questions that you think we may have addressed. If you would like us to address regional center or project related topics, please feel free to contact us. Contact at carolynleePLLC.com. That feedback is very welcome. Okay, there's one more question and then we'll close up. If the NCE decides to not use a fund administrator and opts for an audit, does the audit requirement apply to all JCE or only affiliated JCE? Okay, I think this is a question that we will table. We are seeing questions about fund administration on subparagraph Q of the EB-5 Reform and Integrity Act. So we may address these fund administration questions on a separate webcast. So I'm going to leave it there on that. Okay. But subparagraph Q is the place that you would want to look. Well, everyone, thank you so much again for joining us, and stay tuned for our next webcast. We will be talking about the visa bulletin, what we see as upcoming looming visa backlogs to come. And so stay tuned and look for more materials and information about those. Have a wonderful rest of the day.